Good morning. This is your Kelso Report for Wednesday, April 25th, and I'm your host, Clark Kelso. Today we have cases involving habeas corpus, honest services fraud, juvenile law, CEQA, and criminal sentencing. We begin with the United States Supreme Court. In Wood v. Milliard, the Supreme Court of the United States held that where a state deliberately waives a limitations defense to a petition for writ of habeas corpus, a federal court abuses its discretion by sua sponte resurrecting the waived defense and then dismissing the petition for lack of timeliness. In Wood, the state had twice informed the district court that it was not challenging the timeliness of the habeas petition. The district court proceeded to the merits and denied relief on the merits. Nevertheless, the 10th Circuit ordered briefing of the timeliness question and affirmed the denial of relief, but solely on the ground of lack of timeliness. Well, the Supreme Court unanimously reversed, noting that the principle of party presentation generally precludes courts from raising issues sua sponte that have not been presented by the parties themselves. A narrow exception exists in the context of habeas cases where the court has recognized that structural and institutional concerns regarding comity for state court processes permits federal courts to raise inadvertently overlooked procedural bars, such as exhaustion and timeliness. But that narrow exception does not apply where the state has deliberately, and in this case twice deliberately, stated its intent to waive a timeliness defense. Next, the 9th Circuit in an en-banc decision. The defendants in United States v. Milovanovich were indicted for honest services fraud under 18 U.S.C. sections 1341 and 1346. The main issue before the 9th Circuit was whether a breach of fiduciary duty was an element of a conviction for honest services fraud. Well, the en-banc unanimously concluded that a breach of duty was required, consistent with the Supreme Court's recent decision in Skilling v. United States in 2010. But the 9th Circuit also held that the fiduciary duty did not need to arise from a formal or classic fiduciary relationship. Instead, the criminal statute reaches other relationships that involve a comparable duty of loyalty, trust, or confidence. The defendants argued they were not fiduciaries for purposes of the statute because they were independent contractors to the state of Washington who were hired to test applicants for commercial truck drivers' licenses. The 9th Circuit rejected this argument, however, concluding that the definition of fiduciary is flexible enough to encompass a contractor hired to honestly and truthfully administer written and skills tests and to interpret and certify those results for purposes of issuing commercial driver's licenses. So, when the defendant then engaged in a scheme of bribery and kickbacks to corrupt the process and issue licenses to unqualified applicants, the breach of fiduciary duty element of honest services fraud was met. Next, we have a dependency case under California Court of Appeals. In In Re DM, the trial court entered a judgment terminating parental rights over two siblings, DM and Noah M., and selecting adoption as the preferred permanent plan for them. Well, DM and Noah M. were younger half-siblings of the appellant, Thomas L. And Thomas L. argued that there was insufficient evidence to support the findings of adoptability and the inapplicability of the sibling relationship exception to the adoption preference. The 4th District held that the sibling relationship exception did not apply here because there was sufficient evidence that the relationship between the half-siblings was not particularly strong. As the court explained, quote, while DM and Noah have a pleasant relationship with Thomas most of the time, he did not show the termination of the sibling relationship is sufficiently detrimental to DM and Noah to preclude termination of parental rights, close quote. On the question of adoptability, the court held that Thomas L. did not have standing to challenge the court's finding because the finding does not affect any cognizable right of Thomas L., who was, after all, a half-sibling and not a parent. Next, we have a CEQA case out of the 3rd District, where the 3rd District in Citizens versus Open Government, or Citizens for Open Government versus City of Lodi, brought to an end an almost decade of litigation about siting a Walmart supercenter in a lot across the street from an existing but smaller Walmart store. The court's opinion addresses 3 actions that were consolidated in the trial court under CEQA. The plaintiffs were 2 citizens groups, Citizens for Open Government and Lodi First, and they were challenging reapproval by the defendant City of Lodi of a conditional use permit for a proposed shopping center project after the original EIR for the project was revised and recertified following an initial appeal and remand. The trial court granted the city's request to discharge the December 2005 writ of mandate and denied Citizens and Lodi First's petitions for writ of mandate. On appeal, the plaintiffs alleged deficiencies in the administrative record and the revised EIR and alleged error in the trial court's ruling precluding them from challenging certain issues based on res judicata. Well, the 3rd District found no errors in the revised EIR. They agreed that certain issues were previously resolved and not open for renewed challenge, and the court held that the administrative record, in fact, was complete. The most interesting holding was that the trial court's denial of a motion to require the city to disclose certain emails the city claimed were subject to a deliberative process privilege should have been challenged earlier by a writ of mandate at the time the trial court denied the motion. Because to secure a reversal on a subsequent appeal, the appellant needed to establish prejudicial error. And that's virtually impossible to challenge successfully, since the contents of the emails were never disclosed. This sounds a lot like a catch-22, but that's what the court held. No prejudicial error at the time of appeal. You should have filed a writ of mandate earlier to challenge the refusal to disclose those emails. Well, next we have a criminal sentencing case in People v. Gisbert, where the trial court initially awarded the defendant 88 days of pre-sentence custody credits after defendant pled guilty to second-degree vehicle burglary. The court later granted the prosecution's motion to vacate the credits because the defendant was not entitled to any credits on the second-degree burglary charge, as he was already committed to state prison in connection with an earlier burglary conviction. Since the award of pre-sentence custody credits, where credits were impermissible, made the first sentence unauthorized, the 4th District held that the trial court had jurisdiction to entertain a post-judgment motion by the prosecution to correct the sentence. Finally, the defendant in People v. Guemelin was a physician convicted under Section 650 of the Business and Professions Code for paying illegal kickback fees to persons who referred patients qualified for federal and state programs to her practice. She contends the state statute is preempted by the federal Medicaid anti-kickback statute under the doctrines of implied conflict or obstacle preemption. Well, her conflict preemption argument is that the federal anti-kickback statute requires a higher scienter than does Section 650, making compliance with both federal and state law impossible. Well, this argument misses the point, since the federal statute essentially supplements rather than supplants the state law provision. The federal provision essentially isn't in conflict with the state law, it simply provides a higher standard. For the same reasons, the defendant's argument that the state provision is an obstacle to the congressional objective of providing health care services to the underserved, well, that argument misses the point. The purpose of the state statute is exactly the same as the basic purpose of the federal statute, eliminating conflicts of interest in physician referrals that drive up health care costs. And that's the end of today's Kelso Report. Have a great day in the law.